Hello. Thanks for joining us this afternoon if you're where I am, or good morning if you're to the west of me. This is Dan Lohman from Grenzebach Lear & Associates, and this is the next in the GG&A webinar series, a bit of a special edition on understanding the recent HIPAA final rule. If you don't know what that means, it's going to be a long phone call, but we're going to talk a little bit about that. And I, of course, want to focus on its applications for fundraising. A couple of housekeeping notes. I'm hoping to keep this webinar relatively short and give those of you that have questions the opportunity to ask them. At the top of your screen, you'll see a green bar indicating that you're participating in the webinar, and if you hover your cursor over it, one of the options is to chat. If you send a chat to the host, we'll receive that here in Chicago, and we'll compile the questions, and we'll try to address as many as we can at the end. Any questions that we're unable to get to or that we need to do a little research on, we will be sending an email in the next several days with more complete answers to all of those. Similarly, you may communicate with us that way if you have any audio problems or other technical issues that we may be able to resolve from our end, so please don't hesitate to do that. So again, my name is Dan Lohman. I've been with GG&A for 14 years and have spent the last few years focusing a good part of my time on grateful patient fundraising and, of course, the rules and regulations that surround that. It's probably the most heavily regulated part of fundraising in the areas that we all work in, and there's consequences to that. So we have all kinds of opportunities to start to look for ways to work within the law and the spirit of the regulations for patient privacy, and I want to talk about how some of these recent changes will impact that. What I want to focus on today is first just a quick look at where we've been in the last 10 years as it relates to the Health Insurance Portability and Accountability Act, as HIPAA is formally known. What is the final rule, what that even means, and what's contained in it. 4 points from that final rule that have direct impacts on fundraising, and I'll give away a punchline here. Many of them are quite positive from a fundraising perspective. This I would characterize as good news to the extent that we can all get excited about a departmental regulation on a somewhat obscure law. Some next steps, some things that many institutions will want to undertake almost immediately to start to prepare for the new regulations, whether you have an active Grateful Patient program or not, as well as some more specific steps to think about over the slightly longer term to really get the most out of these regulations while thoroughly respecting patient privacy and confidentiality and operating within the regulations, but also using that to make your fundraising more efficient and more successful, and as much time as we can for your questions. In 2003, several aspects of the 1996 law, HIPAA, went into effect after a period of public comments and implementation periods. Most of these things you already know. A number of rules went into place that limited the amount of information that was available to fundraisers about patients. But a lot of those rules were vague, and we ended up having a lot of conversations about how you interpret HIPAA. Are you a conservative operation? Are you liberal in your interpretation of it? And we hear about places that were some people would say they're really pushing the boundaries. That would never be permitted here. Names and addresses were generally always considered okay as something to share between a healthcare operation and its fundraisers. But then we started to get into a lot of gray areas. If a cancer center that almost exclusively deals with cancer patients is allowed to solicit patients about what they do, how come the oncology department in a hospital can't? And then we got into debates of could cancer centers do it at all, and of course they did. Hospitals started to look for ways to be specific and engaging with their potential patient prospects, but there were always some questions about whether or not this was permissible or not. The 2009 HITECH legislation, which was part of the Recovery Act, the stimulus as it's called, clarified a lot of the technical issues and set standards for data collection and data dissemination within large parts of the healthcare industry, and also set out fairly consequential penalties. As you know, there's significant financial penalties, even for non-negligent errors or a case where someone is not specifically out to do harm using the data. And that led to a lot of anxiety in fundraising as people start talking about, you can go to prison for getting HIPAA wrong, which turned out, thankfully, to be a bit of an overstatement on the fundraising side. I don't know of any cases where criminal charges were filed on the fundraising side of HIPAA applications. But there was certainly anxiety about it. And I do want to note that California in particular, although there are a number of other states that have additional rules that supersede HIPAA. They tend to be stricter than the HIPAA regulations. In the case of California, there's been judicial rulings on the implementation of CAMEA, the California Access to Medical Records Act, that do limit use of patient information in ways that are either contrary to or not specified by HIPAA. So particularly in California, but in any state, as you work with your compliance office to implement any kind of grateful patient fundraising program, those individual rules will need to be taken into account, those individual state rules. So let's start by answering the first question about what is a final rule before we even get into this particular final rule. So after a complex piece of legislation, any legislation, passes Congress and is signed into law, a government department, in this case Health and Human Services, is tasked with enforcement and clarifying the rules and implementation of that law. So virtually any federal legislation ends up with a series of rules that are meant to be more specific about how the law itself will be implemented in practice. There's more than one final rule as it relates to HIPAA HITECH. There have been final rules issued in 2003 and 2006, as well as 2009, related to different parts of HIPAA law. And this final rule actually has a longer name involving breach notification and security. It is, that said, the final rule as it relates to HIPAA and HITECH right now. There's no more expected comprehensive rules being issued. So this most recent final rule was issued just a couple of weeks ago in January, and I was so excited when I got an email about it that I called home and said I would not be home until late that night as I dove into 563 pages. I think this stuff is pretty cool. The rules take effect on March 26th, meaning we've got a few months to clarify how we might begin to adapt to the new rules, but enforcement doesn't begin until September 2013. So there's a 6-month period where we can begin to act on some of these changes and the final rule before the rules formally take effect, as it were, and potential consequences come into play. So that 6-month period is intended to help institutions work with their compliance office and legal counsel, change their operational practices, develop communications and documentation around it, and so forth. Final's not as definitive as it sounds. There may be further changes on the horizon. Legal disputes and judicial opinions may clarify or even invalidate portions of the rule. New legislation is often pending as it relates to patient privacy information, and that can have an impact here. So we still need to continue to monitor these things. If you are on GG&A's various communications distribution lists, we update our clients and people on that list with changes that we think are germane. So we encourage you to be a part of that if you're not already. At the end of the presentation, I do have a link to the final rule itself, and we'll send that out as part of the follow-up to this. So if you are in for a good night's sleep and you want to plow through some of that, feel free. Although most of the fundraising language is focused in a 20-page section right in the middle, pages 210 to 230, where almost all of the things we're going to talk about today are more specifically described. They make me say this, and it's true. GGNA is not a law firm, and we can't provide legal advice. So while we are talking about legal issues, and those legal issues have consequences if you get them wrong negligently or not, or criminally or not, nevertheless, you'll want to check with your legal counsel and your compliance office. And I want to emphasize that while the penalty portion makes HIPAA a serious business, certainly at GGNA, we're firmly in favor of HIPAA HITECH broadly as necessary and important protections for patient privacy. And certainly many of us listening today are not only in the fundraising side of healthcare, but we inevitably interact as patients. And HIPAA's there to protect patients and ultimately to protect healthcare organizations in the course of delivering service. The best fundraising operations are partners with their compliance offices, and I know we have some compliance people on the phone, and I'm not putting that in there simply to blow smoke. Compliance offices exist to protect their healthcare organizations from these rules and deviations from these rules, and partnerships where the compliance office understands development goals and vice versa tend to be more effective than the occasional fundraising operation that we come across where they do say things like, we want to put things in place and we're going to try to skirt around the edge of this issue as much as possible. We don't encourage that. We really want you to work with your compliance offices to have the best possible implementation so that everybody feels comfortable with this program, from the CEO of your organization all the way down through a patient walking through the door today that has expectations about how you use that information. So what's new? The big one. Fundraising offices are now very clearly permitted to receive and use certain medical information that was not previously available, or at least not clear as to being available, in terms of their interactions with patients and patient families. This includes broad Department of Service categories like cardiology, neurology, and so forth, not specific diagnoses and so forth. We still need to maintain a certain level of generality, although it's much more specific than has been previously noted, and is probably as specific as it really needs to be from a development and fundraising perspective. The treating physician, again, we'll talk about the implications of all of this, but knowing who the primary physician is in any particular patient interaction can have value for communications and structuring any potential cultivation. And something that was unexpected in this final rule, an indicator of outcome. The rule is clear in its vagueness, which is to say that we can't talk about very, very specific outcomes, but can categorize those outcomes into general chunks like successful, suboptimal, or deceased. Deceased being an important one, particularly as you think about things like phone programs and direct mail programs. You can now receive that information if it's known by the hospital, as opposed to risking sending solicitations to deceased families that don't acknowledge that sort of thing, or potentially creating an uncomfortable situation. This is one area that we'll talk about in the next steps, where you'll probably have to create some kind of tag or flag on the patient information system, and then ultimately the data received by a fundraising office, because these broad categories don't necessarily exist in a system like Medipac or Epic or the patient data systems that you may have in place. So, again, this critical piece, beginning on March 26th, the development offices and their institutionally related foundations, as well as third-party business associates, such as screening companies or direct mail houses, can receive this information, provided you are protecting it in ways that we'll talk about in just a moment. Next, organizations must be able to demonstrate a specific need to use this information. So this isn't new. This goes all the way back to the 1996 legislation, and it's reinforced in the final rule. You can't collect treating physician or Department of Service or general outcome if you don't have a reason to use it. If you're still sending blanket mailings about the value of the institution or the importance of philanthropy, and you're not segmenting based on Department of Service, treating physician, or general outcome, outcome, you're better off not collecting it in the first place. If you don't need it, don't take it. And that applies to individuals within the office. Only people who are working with the information should have access to it, and you'll want to maintain a system that limits access to this protected health information to those people on the fundraising side, the development services side, the communication side that are directly working with the information. Now, keep in mind, your ability to now collect this information does not mean that it is no longer protected health information. It is still absolutely protected health information, and that makes you, the fundraisers and the development side, that much more liable in your interactions with this information. You know, in the obvious but unlikely case of leaving a big printed list of patients with a treating physician on the bus, if that list is longer than 500 names, you may be dealing with a formal breach of the HIPAA security rule that requires notification, it requires remediation. With your compliance office, you'll need to know the rules and what to do next in those situations. Even if it's only a couple of names, it's still something that you would need to report internally, generally speaking, and work through your own internal processes for dealing with those incidents if they don't actually constitute breaches. So keep in mind, just because you can have it doesn't mean you can be any more careless with it. On the contrary, you probably have to be more careful with your protection of that data from a HIPAA perspective than you were before. So this new information is in addition to data that you were previously able to get. There's never been much argument about name and address, guarantor contact information. Some of the other things that are on this list, there have been some debate about, and they're now clearly specified in the rule as permissible protected health information. There had been some argument in the past about date of birth versus age. You are now able to collect date of birth and use that information, as opposed to strictly age. Insurance status, is somebody self-pay, do they have private insurance, Medicare, Medicaid, and so forth. That is probably, arguably, the least important of the data items from a development perspective, but at the same time, if you know someone is on a low-income health insurance program, that may help you to limit your expenditure and communications with certain groups. Self-pay can go either way. It can be someone who can afford to write a check for their insurance or someone who can't pay at all. Again, we have to work with that vagueness. Dates, the plural being important there, is newly permissible. Previous rules talked about date of service, and it was unclear sometimes if that meant the most recent date of service or all dates of service. All dates of service are now permissible. You can use that information to prevent duplication. If somebody visits your inpatient facility 3 times in a year and your outpatient 5 times in a year, this can help you prevent mailing to that person or communicating with that person 8 different times. You can also use it for different kinds of testing and segmentation. Are people who are patients more often or less often better prospects? Do you have higher or lower response rates? And I think there is a lot of testing to be done there, and I guess I'm drifting a bit off HIPAA and into implementation of some of these things. But there are a lot of questions being asked in healthcare organizations. Are people who are inpatients a lot and therefore likely to be very sick as opposed to less so, they may actually be worse financial prospects from a fundraising perspective than someone who had fewer interactions with a positive outcome and are feeling positive about that. Again, that's a debate that's unsettled. We now are able to collect data to do some testing on that. And finally, location and site of service. This generally applies to systems or healthcare organizations that have a campus with multiple facilities. Now, in addition to identifying inpatient versus outpatient, we can look at those different areas. Again, in the past, that has been a concern because if somebody was a visitor to the adult Down syndrome clinic, that is a pretty solid clue to a relationship to a specific diagnosis. As long as it remains fairly general, this is now permissible information. Medical record number, a piece of data that of course exists on the patient census, and is sometimes transmitted to the development office on a list of daily or monthly admissions, is not specifically included as permissible. And because of that, and because of the fact that there are ways to cope with this, our position is we would discourage you from using an unmasked medical record number. Lots of organizations build a code system where you apply a mathematical formula, add 7 to the n, divide by 3.5, multiply by 24, and that's the number. So you can encrypt it on the way out using that and decode it when it goes back into any data system where you need to connect two pieces of information. Number 2, also, I think a big potential change and a major clarification that should ease our anxiety and our implementation of Grateful Patient programs. The final rule clarifies opt-out language rules for fundraising. So first off, and again, some of this repeats practices that you already have in place, in all communications involving a solicitation, an invitation to an event where there will be a solicitation, anything that you might broadly consider to be the practice of raising money for your organization needs to include clear, simple, lay language indicating that the recipient, the patient, or the patient family may opt out of receiving these fundraising communications going forward. The rule is deliberately open about how you implement that. They specify only that it needs to be very low cost and very low burden. They specifically mention a toll-free number, a local telephone number, if you only serve a local catchment area, email, websites, but they leave it to institutions to determine what is reasonable. If you serve a community that has very limited access to the internet, having only a website would be considered too burdensome. And for many of the larger organizations that are on this call, which is virtually everyone, and by larger, I guess I would be excluding very small clinics, single proprietor physicians' practices. Most of the organizations on this call would fall into that larger category. You'll probably need more than one of these. Requiring a patient to write a letter is specifically prohibited. It's considered that it imposes too much of a burden. You can have it as one of the options, but you have to also offer one of the other lower cost, low burden mechanisms to do this. An opt-out is an opt-out. If somebody opts out, the rule specifies that you should treat that as across the organization for fundraising purposes, although there are some openings in the rules about how long that opt-out lasts. Is it forever? Is it a period of a number of years? Again, our general sense is if somebody opts out at some point, we should probably maintain that fundraising opt-out until they indicate they want to opt back in, which they can do, but then limit their communications to educational or other kinds of marketing communications to avoid a touchy situation. Thankfully, frankly, having been on the other side of trying to sort through this issue, the rule does acknowledge that 100% accuracy is an unattainable goal in terms of managing opt-out lists. The rule specifically talks about duplicate records. If I'm an outpatient one week in one department and an inpatient in another department the next week, it's conceivable that one of those records could have the opt-out tag, the other one does not. As long as you're applying a reasonable, good faith effort to consistently keep this data current and up to date, that's considered acceptable. Again, this does not suggest that you should be lax in any way about this. 100% should be the goal, and you want to be able to demonstrate that you're attempting to reach that 100% standard. But if you've already sent a list to the mail house and somebody opts in 3 hours before the letter hits the mailboxes, you don't have to run to the warehouse and pull that letter out. There's an acknowledgement that there's a time lag sometimes. Very importantly, the rule applies to verbal as well as written communications. So this isn't just the direct mail program, but if you're calling people, if you're visiting them, you do need to communicate that they have the opportunity to exclude themselves from these fundraising communications. Our recommendation, and this is not specific to the rule, but our recommendation is that anytime a member of your staff delivers verbal opt-out language, talking to someone on the phone and says, just want to let you know, if you don't want to receive further fundraising calls, we can take you off that list. That should be documented in a central system so that if there's ever an issue, you can report back definitively that somebody had in fact done that. I'm also encouraging pre-printed cards or even putting the one sentence on the back of business cards that specifies the opt-out language. So while you're meeting with someone, if you hand that over, as you would anyway with other communications or with your business card, you're providing that opt-out. You can document that information. It's a way to honor the spirit of the law, provide the patient with the information that they need, and ensure that you're in compliance. So in terms of things to start thinking about, again, in coordination with your compliance or your legal counsel's office, although the development office may need to be the driver of some of these changes, as the compliance office certainly has many other things to worry about. Remember that it's a 563-page rule and fundraising applies to 20 pages of it. Your compliance office is working with those other 543 pages across your organization, and I think they would appreciate if you can bring to them a clear plan. Certainly make sure fundraising language is included in the notice of privacy practices that you deliver to all patients, typically at the outset of their care during admission or registration. Evaluate a process for phasing out HIPAA philanthropy authorization forms. And that's a lot of syllables, but I hope there's a sigh of relief. The rules would seem to indicate that requiring a signature to formally opt in to a healthcare discussion are no longer necessary. If you've provided this information in the Notice of Privacy Practices and communicate the opt-out language throughout your discussions, unless you would need medical information beyond that that's authorized here, and that may happen, and if you have some thoughts or examples or scenarios where that might happen, please let us know through the chat function. I can't think of any. You may then need opt-ins, but at this stage you should not. Agree on simple and clear opt-out language and what that opt-out process is going to be. You now need to have a formal standard opt-out process, and that language needs to appear in many places. But it doesn't have to be 27 lines of 3-point font in legalese form. It can be a sentence, again, written in lay language that says that you are not required to receive fundraising communications, and if you would like to stop receiving those from this institution, please call this number or go to this website. Training development staff on the new rules and new processes, again, the immediate next step is to begin thinking about what that looks like. And perhaps in a slide or two, when we start talking about some of the slightly longer term implementation modes, this might become part of that practice. But as you start working directly with physicians, if you start segmenting your patient population based on area of service or by physician, your staff will need to know how they can use it, what rules they need to follow, what they need to do if they perceive that there's been a potential incident or misuse of that data, deliberate or not. Probably should have put this in bold. Remember that permissible does not necessarily mean advisable. And there's no hard and fast rule on this one. You now have access to things like Department of Service and treating physician, but you may have patients who've become quite used to that information being unavailable to the fundraising department, applying common sense, sensitivity, communications best practices about how we work this new information into our discussions with prospects is going to be important, and I think that's going to play out over time as we see examples of both good and bad implementations. Staff do have to be prepared to sometimes be put on the spot. There will be patients who say, how do you know this about me? I didn't think you could know who my doctor was. And you'll have to have a sentence for them to deliver explaining that they can have it if you as the patient would like the development office not to have it, you have that opportunity as well. And as you develop this plan, communicate with your compliance office about how you want to implement it, and we'd like to encourage any organization, if you're not already doing it, to have a standard set of review meetings with their compliance office that happen on a regular basis, not only during these times of transition, that if every 3 months or every 6 months you can set an hour out with your chief of compliance or the legal counsel responsible for this area, just to make sure that your practices and policies are in step with what they're concerned about, that can tend to prevent larger problems down the road. So slightly beyond the next week or two, we can now start thinking about all of the things that are available to us. And if we think back to 2003 and the run-up to HIPAA as we've known it, this isn't a return to that. Certainly there's a lot of rules and regulations that are in place now that are not going away. And perhaps even more importantly, Grateful Patient fundraising as a specific formal program was in its infancy in 2002 and 2003. Not many organizations were doing it in a formal way as opposed to the sort of general interactions that they might have had with patients. So rather than a return to 2003, we now have to think about how, from a communications perspective, we might communicate with cancer patients about cancer research, or with expectant mothers about neonatal care, whatever ultimately makes sense. How can we use tests, make determinations about appeals signed by a physician or a department chair? We are not limited now to the CEO of a hospital or a well-known name necessarily being the signatory on communications to prospective patients. We can narrow that down to a department chair, a specific physician that may be working with specific patients, and all of those different possibilities. Over the last 10 years, physician development committees, and in some cases nursing development committees, have been formed as a way to review prospect names, asking physicians to bring potential prospect names to development, or the other way around, of development offices saying, here are some names that we're potentially interested in, does anyone have a relationship? We can now skip that step because we can now connect them to specific physicians, and one of the things we want to start exploring is creating, a cardiology physician group, a pulmonology physician group, an oncology physician group, so that we can work with specific and focused names. As many of you know, physicians do not particularly enjoy spending large periods of time in development meetings reviewing lists that don't apply to them. This is a way to get around that, not get around it, get right to it is what I should say, and present those names to physicians who are specifically interested, and of course, particularly focusing on those physicians that want to work with you. As you think through how this data might be used, you may have third parties that use this information. Certainly wealth screening companies, and we'll show you an example in just a second. This may be data that you send along with your records. You will want to ensure that that your partner direct mail firm, screening firm, is a business associate and has the legal documentation in place with you, as well as asking for confirmation of certain security standards in terms of limited access to your data, encrypted storage of that information, and other kinds of issues like that. As some of you know, in less than 2 weeks, DonorScape, GGNA's wealth screening product that we use for patient screening, is going through a major upgrade, and you can see that we've, in some customizable fields, have now created places for Department of Service, treating physician, and the outcome flag. As I mentioned, these are completely customizable. So depending on how your organization decides to implement these kinds of categories, your external vendors should be able to create storage mechanisms and ways for you to draw out that data in a way that's fully compliant. We'll send this to you because these are some long links, so you probably won't be able to copy them down before I'm done with this slide. But a few links that may be of interest. The final rule itself at the Federal Register, we've updated a white paper on the broad implementation of grateful patient programs that you can find on our website. In addition to talking about these 2013 changes, it gets at some of the larger issues related to successful grateful patient programming. And there are 3 prior webinars from the GGNA webinar series on grateful patient programs that include, in some cases, GGNA staff, but in a number of cases, some of our client institutions and their specific case studies with successful programs, and you can download and view those for free at any time. I am not excluding the AHP website out of any form of spite on this slide. Their website has not yet been updated with this information. When I checked this morning just to see if anything had gone up, it still says the final rule has not been finalized. So I suspect that they're reviewing its implications, and certainly our partners at AHP will be communicating about this as well. So I'm excited about the opportunity that's presented here, and while we continue to need to be very vigilant about maintaining data security and patient privacy, the opportunities that are presented to us here in order to communicate directly with patients and patient families in ways that are much more specific to their own experience, which of course we know is the driver in any fundraising communications, I think it's a great opportunity to start to see continued growth in grateful patient programs, more directly move certain prospects into major gift cultivation, and even increase direct mail response and other forms of successful fundraising by being able to speak to individuals' specific circumstances. So I'd like to open this up to you. We have a few questions that have come in already, and I'd like to address them. The first one is, I'm wondering if you could elaborate on the opt-out in verbal communication. Specifically, how often do you suggest that the opt-out be given verbally? That's a good question. I would certainly say at the outset of communications, and this is another piece of value in having that pre-printed card or having that on other leave-behind materials, because you can deliver that opt-out information non-verbally at other times. I think in a major gift cultivation, it does not need to be in every interaction, but periodically makes sense and to reinforce that it exists, especially if you're delivering printed matter that you can document as delivering the opt-out information. Do acknowledgement or thank you letters need to contain opt-out language? A good question. If the rule uses language along the lines of in any communications that are related to a solicitation or the practice of raising money for your institution. So this is a clear case to check with your compliance office. My non-legal opinion is that in an acknowledgement letter thanking for somebody for something they've already done, it's probably not required, but at the same time, it's probably a good idea. It's another opportunity to present it. It doesn't have to be obtrusive, and it's one more case where you can document that you've done your part. I'm going to read another question here. If we have gathered information about a prospect prior to them opting out, do we need to have systems in place to remove previously captured information, or is it mainly going forward? That's an excellent question. The law deals as much with what you know about a patient as it does with what you do with that information. And the action part is probably the more prevalent component. So my understanding is that you would not need to retroactively go back and systematically remove that information, but you couldn't act on it going forward at that point. So if your system did indicate that this person had been a patient in cardiology, you wouldn't be able to communicate with them anymore about development issues or specifically mention of the cardiology program, but that you wouldn't have to retroactively remove it. If you have a concierge or other navigation program as part of your program, you may need authorization because to really navigate well, you need access to a great deal of the electronic medical record, including specific diagnoses. Thoughts? I think it's a good question, so let me restate that. That if you have a concierge program, a patient coordinator, where you're moving a patient from place to place, you're maybe in the room when medical information is being discussed or disclosed, does that go beyond what the current rules permit without authorization? The answer is yes. That if the fundraiser is, or a representative of that part of the staff is deeply involved or is in any position to have information beyond that broad Department of Service information about a specific medical procedure, an authorization is advisable in a case like that. How do these rules apply to mental health or addiction patients who are treated at a specific behavioral health hospital, which is part of a multi-hospital system? Can you mail them about mental health issues? The rule isn't specific about certain kinds of, in this case, this use, about protected services. We've seen an increase in fundraising related to psychiatric and psychological care, finding that there really are a lot of grateful patients in that category who have received positive outcomes in treatment, and families who've been thankful in those kinds of situations. I think that these broad rules apply. I think that the common sense and sensitivity issues apply as much here, if not more so, than they do in other parts of the program, but I don't think that it's a specific limitation. Our legal team is stating that we cannot change anything until they resolve potential conflicts with our state laws. Do the federal rules trump state or vice versa? I guess it's the stricter of the two is the one that will take precedence. So it's not, if your state law has more pronounced rules than the federal rules, the state law will take precedence. If your state laws don't exist in this area or are more lax than the federal law will prevail. So the legal team is right in that making sure that any of these changes are not trumped by those state rules. And as we talked about at the outset, in California, most of these new changes will not have any impact on the development programs in that state because of the stricter CMEA rules. Another question, the question is, I'm wondering if you could elaborate on the opt-out in verbal communication, specifically on how often is it given verbally in telephone calls. Again, I think it depends on the type of phone call. I think if you have a phone-a-thon type program where you're calling a couple of times a year to different households, I would present that information as often as possible. Discuss with your compliance office if annually or every 6 months is sufficient. If you get somebody on the phone a second or third time, do you have to repeat the opt-out? And you'll get an answer from them. My general sense is that delivering that opt-out information consistently and in most of those kinds of interactions is probably the way to go, especially since in its clearer interpretation as it relates to written communications, it does need to be on virtually every written piece of material. So I think each phone call probably requires its own delivery of that type of language. Now, it doesn't say when that communication has to be delivered in a phone call, so it could be in the middle or toward the end. It doesn't have to be the first word out of your mouth. The next question is, are service line specific solicitation and events now permissible under the new guidelines? Yes. is our interpretation, as long as you keep them broad enough to fit into those medical thematic categories. You can invite patients of the cardiology department to a cardiology lecture that contains a solicitation, or send them information from the chair of cardiology about things going on in the cardiology department permissibly, as long as you provide the opt-out language and comply with the other sets of rules. You can't be more specific than that, if someone had a cardiac catheterization, you can't send specific information to them about cardiac catheterization unless it's also part of a broader communication to people who were not also in that program. So the short answer is yes, that the medical thematic areas that many gift officers represent can now be segmented on their own, and you can communicate specifically about that information. I have one last question. Can we start making changes now? The rules go into effect on March 26th. So anything that happens between now and then needs to be planning. And only on or after March 26th can you actually start implementing these changes, and need to have all of those processes finalized by September 26th, that 6-month period of time. If any other questions emerge, you are more than welcome to send them to us. My email address is on the screen in front of you, and there's also email information from my colleagues in the invitation that you received. Feel free to send any additional questions to either me or my colleagues Lana and Anthony, whose email addresses you have. And we'll respond to them in an email. So in the next few days, we will send to you a copy of this presentation with the links that we provided, answers to any additional questions that we weren't able to answer so far, and any other questions that come in. So good luck as you start to work through the new regulations. We look forward to working with many of you on bringing the processes that we have in place with you in line with these new regulations, and thinking about the future, about how we can use this new set of rules and regulations to the benefit of institutions and healthcare philanthropy. So thanks for joining us, and we look forward to working with you soon.